Hello, everyone. I would like to welcome you to our webinar where we will take a look at some recent family law cases. My name is Andrea Collins Fitzpatrick, and I'm the Legal Director for METRAC's Community Justice Program. I would like to begin with a land acknowledgement. Although we may all be located in different places right now, I will acknowledge the territory in which our METRAC is physically located. We acknowledge that this land is the traditional territory of many nations, including the Huron-Wendat, Haudenosaunee, and the Mississaugas of the Credit. Today, the meeting place of Toronto is still home to many Indigenous people. We honor all the First Nation, Métis, and Inuit people living on this land. We recognize the traditional territories on which our organization is located and on which our programs and trainings take place. I would like to remind you that this webinar is for general information purposes only and is not legal advice. The legal information provided is not intended to be used as legal advice for a specific legal problem. The webinar will be recorded and will be posted on our website at onefamilylaw.ca. Before I move to our presenter today, I would like to tell you a little bit about METRAC. METRAC works to end gender-based violence across communities through education, research, and policies. We have been in existence since 1984, and our programs are devoted to advancing safety, justice, and equity. METRAC's Community Justice Program provides legal education and information related to gender-based violence. Through our Access to Justice program, we provide legal information in areas of family law, immigration law, criminal law, employment law, and human rights law. This webinar is part of our Family Law Education for Women FLU series. FLU's resources are available in 14 languages, ASL videos, and accessible formats. You can visit our website at onefamilylaw.ca for more information on your family law matters. I would also like to thank our team, Fiza Malik, our project lawyer, Emma Cowell, our coordinator, and our technician, Brian Bernard. I'm delighted today to have Valerie Dye to discuss some family law decisions from 2024 that are worth highlighting. Valerie is owner of Dye Law, of which she is a sole practitioner. Her practice focuses mainly on family law, real estate, and wills and estates. Valerie has also taught business law at Toronto Metropolitan University as a sessional lecturer. Valerie was first admitted to practice in Guyana, where she practiced briefly before moving to St. Kitts and Nevis, where she worked as Crown Counsel for the Ministry of the Attorney General. She later attended the University of Manchester in the United Kingdom, where she did postgraduate studies and where she also taught for a number of years. Valerie has also taught at the University of Liverpool online LLM program. Valerie was called to the Ontario Bar in 2013 and has been in solo practice since February 2014. Valerie has also contributed to METRAC's Family Law Education for Women website, and we are grateful that she continues to collaborate with us. Thank you, Valerie, for once again taking the time to share your knowledge with us. I'll now pass things on to Valerie.
Thank you, Andrea. It's a pleasure once more to be a part of METRAC and to make my contribution to family law education for women. I feel really honored to be able to do so again. And today I will be discussing a few family law cases that were determined in 2025. And those cases are based on separation agreements, spousal support, parental alienation, child support, and then we have one case that deals with whether a child can choose their own parenting schedule. And so I hope you'll find these decisions very helpful moving forward. And so the first case I will start with is Davies and Jane, which was an Ontario Court of Appeal case, and it deals with separation agreements. Just by way of background, the parties in this case had been in a 21-year marriage, which is considered quite a long marriage. They had 4 children. The wife was a homemaker. The husband was an Ontario government employee and earned about $80,000 per year. Now, the parties experienced some financial hardships at separation. The home was at risk of foreclosure. And so in an effort to deal with that, they first had a separation agreement that said that no support would be payable. And that was for the benefit of the bank to help with the transfer. And then they subsequently had another separation agreement, which was the final agreement, which provided for support and for division of property. And it is worthy to note that the same lawyer had been involved from the beginning, assisting both parties, and we will speak more about that later. So the term of the second separation agreement, the second separation agreement provided that the husband will pay the wife spousal support of $28,200 per year. And there were some conditions to that. One condition was that except that she remarries. In other words, he will pay support and the support will be terminated if the wife remarried, if she cohabited in a relationship resembling marriage for one or more periods totaling 3 years, or obviously if she died. The wife subsequently entered into a cohabitation. And so the issues in this case was that the husband paid support for 5 years and then he suspended the payments in December 2020 because the wife had started a relationship with a man living in Texas. And so the husband at that stage felt that he could bring into the terms of the agreement, which said that his spousal support ended if she entered into a cohabitation with another person. And so on that basis, he terminated spousal support. And the wife at this stage moved to the courts to have the separation agreement set aside, because that separation agreement provided that if she was in a relationship, she was no longer entitled to spousal support. Now, at trial, the judge set aside the agreement, and the ground for the judge setting aside the agreement was that it was not negotiated fairly. Remember, we had said that the same lawyer assisted both parties for most of the case from the start, almost to the end, when at that point the lawyer felt that he should remove himself, but by then he had already represented both parties. So the trial judge decided that the agreement should be set aside because it was not negotiated fairly in his eyes, and also that the wife did not fully understand the nature of the agreement. And obviously, if the separation agreement is set aside, then there's no more limit to the payment of spousal support. The husband will have to pay spousal support regardless of whether the wife remarries or regardless of whether she enters into another relationship. And so naturally, the husband appealed the trial judge's decision to set aside that agreement. So let's look at what the Court of Appeal decided when this matter was appealed. Now, we should know that Section 56(4) of the Family Law Act allows the setting aside of a domestic contract. Now, a separation agreement is just one domestic contract. There are other domestic contracts like a marriage contract, cohabitation agreement. Any domestic contract can be set aside for various reasons. One of the main reasons, if a party fails to disclose significant assets or significant debts or other liabilities that exist at the time when the contract was made. Now, obviously, if one party has assets worth $10 million and the other party is unaware of that and enters into a domestic contract, that would be a ground for setting aside the domestic contract, because that's a significant asset that was not disclosed. And the other ground for setting aside a domestic contract is if a party did not understand the nature or the consequence of the domestic contract, because obviously consent must be informed consent. both parties should be aware of what they're signing. And if the court finds out that either party was unaware or did not fully understand the nature of what they were getting into, then that contract could be set aside. And then on the grounds of basic law of contract, there are certain requirements for contract law generally. And if those requirements are not met, the domestic contract could be set aside. So that is what guided the trial judge, and that is what the Court of Appeal looked at again. So how did the Court of Appeal analyze this case before making its decision? The Court of Appeal highlighted the fact that the person seeking to set aside the agreement had the burden of proving that the agreement had needed to be set aside. And one of the main things that the court said was that domestic contracts should be encouraged. In Ontario, in Canada generally, domestic contracts are encouraged. And because domestic contracts are encouraged, courts usually defer in a significant way to contracts and also to what lower courts decide. In other words, if parties decided that they want to enter into a domestic contract, to a large extent, the court usually abides by what is in that contract. They give deference to what the parties want in that contract. The Court of Appeal also analyzed that there may be flaws in the negotiation process. For instance, if the same lawyer is used, that is a conflict of interest, and that's a flaw in the negotiation process. Another type of flaw would be where one party does not fully understand the contract. But the Court of Appeal said that flaws in themselves do not lead to an automatic invalidation of the domestic contract. The courts have some discretion, and they will look at the entire picture in order to determine that. Another thing that the Court of Appeal discussed was that adequate disclosure and understanding was required. And so in this case, the wife knew what she was signing. No evidence was put forward that she was under any type of duress when she signed the agreement. And there was no evidence that she was coerced by the husband or that he dominated her. So there's no evidence of that, and there's no evidence that she did not understand what she was signing, despite the fact that there were the flaws that existed. And the court also said that there must be some prejudice that must be shown. And so based on those things, the Court of Appeal decided that the contract should not have been set aside because the agreement was valid despite the flaws, disclosure was adequate, the wife understood the agreement, and there was no duress or coercion. And so what comes out from this is that it does not have to be a perfect situation when a domestic contract is being entered into. Courts highly respect parties' desire to determine what they want to happen in their separation process. Courts give a high regard to that. And so there's a high threshold to be met before the court sets aside a contract. And so the court decided that on the basis of what the lower court decided, the contract will not be set aside. However, there's another aspect that the court looked at. Remember, in that separation agreement, there is a provision that spousal support will end if there's cohabitation totaling 3 years or more. So the court also looked at that cohabitation clause. And the court decided that the cohabitation clause in itself, not the entire agreement, just the cohabitation clause, was not valid because it did not meet the objectives of the Divorce Act. And what are those objectives of the Divorce Act? The Divorce Act, A, recognizes any economic advantage or disadvantage to the spouses arising from a marriage or its breakdown. The Divorce Act also apportions between the spouses any financial consequences arising from the care of any child of the marriage over and above any obligation for the support of any child of the marriage. The Divorce Act also has an objective to relieve any economic hardship of the spouses arising from the breakdown of the marriage, and insofar as practicable, promote the economic self-sufficiency of each spouse within a reasonable period of time. And so even though the contract itself was valid, the courts have the power to rewrite and to remove any support clause in a contract that does not abide with the objective of the laws. The court can do that for child support, and the court can do that for spousal support. And so in this case, the court determined that even though the contract was valid, that clause that prevented the wife from receiving support because she was in a relationship, that was not valid because there was no economic balance. The wife would still have suffered economically. There would still be a financial detriment to the wife in that regard. And so the court removed that part of the contract, reinstated the contract, but removed that cohabitation clause. And so what are the key lessons that we get from this case? The first thing to remember is that domestic contracts are presumptively valid. The court starts off from a position that the contract entered into between two parties is a valid contract. They start off from that position. It has a signature from both parties. They were a witness, and so that's prima facie, it's a valid contract. Second, in order to set aside a domestic contract, the flaws must nullify consent. In other words, there may be flaws in negotiation, there may be conflict of interest, but the bottom line is that if both parties understand and they're aware of what they're signing and they consent to what they're signing, those flaws will not allow the court to set aside the contract. Another thing the court said in this case, which is quite commonly known, is that joint legal representation is a conflict of interest. The lawyer should not have acted for both parties. From beginning to end, the husband or the wife should have been advised that they needed to get independent legal advice. And so that gave rise to a conflict of interest. But despite that, the court did not find that that was enough to have the contract set aside. If the conflict of interest had given rise to a lack of consent or a lack of understanding or duress by one party to the other, then in that case, the court would have set aside a domestic contract. So domestic contracts, by and large, are highly encouraged by the courts. And for the most part, the courts uphold domestic contract, except in these cases where there's no consent, and of course, where there's a significant lack of disclosure of assets. Now we can move on to the second case, and this one deals with spousal support. And this is R.L. versus M.F., and it's a 2025 Ontario Court of Appeal case. So let's look at the background of that case. Now, this was a 14-year marriage. There were two daughters, one 17, the other 15, and this was a high-income family. The father was a banker, earned more than $2 million per year. The mother, a doctor, a respirologist, and even with the part-time earnings, she earned $350,000 per year. And her earnings were part-time because she had childcare responsibility, household duties. And so they separated in 2020, but they remained in the same house, in the same home until 2021. Now, at trial, the mother, of course, she claimed spousal support. He had a significantly high income, and it was a 14-year marriage. And so she claimed spousal support. And she was awarded spousal support on the basis of moderate compensation as well as non-compensatory ground. And she was awarded $20,000 per month for 9 years, 8 months. And so So the total support duration was 12.5 years. And of course, she was also awarded child support. But for our purposes today, we will look at only spousal support. And the husband appealed the spousal support ground, the spousal support award. And so on appeal, the issues were, was the wife entitled to support even though she did not lose the career? Now, note we said that she was a doctor and she still worked part-time. So she did not lose her career. She only opted to work for reduced hours because she focused on childcare and taking care of the family. And so one thing to note here is that spousal support considers not only economic disadvantage, but it also considers economic advantage. And another issue for the court was the post-separation income increase. Should the mother share in the father's income growth? Let's say he did not earn $2 million at the time of separation, but by the time this matter came to court, his income had risen to $2 million. Should she benefit from that, or should she only get spousal support based on the income he earned during the marriage? And then the other issue was the quantum and duration. Was the award excessive or not? So how did the Court of Appeal analyze this? So one of the first thing to note is that spousal support is not an automatic right. No one automatically has a right to spousal support once they're separated. And another thing to note is that income disparity alone is insufficient. It's not enough to say, well, I earn 50,000, he earns 80,000, therefore I should get spousal support. Even if you do, there's a divorce mate calculation that will obviously show an amount that should be payable for spousal support, but that's just a calculation. When this goes before the court, it's not an automatic right. The court will look at other issues. And Court of Appeal further discussed the fact that child care and domestic work have economic value. And the Court of Appeal further said that imputed income does not bar entitlement. And so compensatory entitlement must arise where, as a result of the parties' role during the marriage, one spouse has conferred economic advantage on the other, notwithstanding the absence of economic disadvantage. What does that mean? Now, spousal support is generally awarded on two grounds, two bases. A basis of to compensate one party for what they've done during the marriage, and the other basis is on the basis of need. Now, in this case, this wife would not have been in need. She earned, even her part-time income was $350,000 per year. So the main issue here was a compensatory ground of spousal support. Now, it is often felt that compensation means you're compensated because you suffered a disadvantage by being a homemaker. You didn't get a chance to further your career, and so you need to be compensated for that. But the court said that compensation is not only payable when you've suffered a disadvantage, but compensation is also payable when you've conferred an economic advantage on the other person, notwithstanding the fact that you did not experience an economic disadvantage. And so, in other words, the wife was working part-time. She earned a certain amount of money. That was not an economic disadvantage to her, but she conferred an advantage to the husband because the fact that she acted as a homemaker for part-time, the husband had the opportunity to go out and increase his income, and therefore he experienced an economic advantage. And on that basis, the wife should be compensated, even though it may be a moderate compensation given her ability to earn, but she should be compensated because she allowed the husband to enjoy an economic advantage. And then the court also looked at post-separation income and outlined a few principles that should guide whether or not the wife should benefit from the husband's post-separation income. And then the court stated that there's a connection between the marriage and the income growth that should be required in order to determine whether or not the wife should benefit from post-separation income. And so what did the Court of Appeal find? The Court of Appeal dismissed the appeal that the husband brought. The Court of Appeal found that the support award was reasonable. The Court of Appeal further found that spousal support may be awarded despite the high recipient income. Now, her income was high, $350,000. The court found that she may still be entitled to spousal support. And the Court of Appeal also found that there was need for moderate compensatory as well as non-compensatory entitlement. And the court found that post-separation income may be shared if it's linked to marital roles. The previous slide mentioned 15 points that the court looked at in terms of post-separation. What are some of those points? A recipient spouse is not automatically entitled to an increased spousal support based on a pair's spouse's post-separation increase in income. In other words, if after separation the other party's income doubles, the receiving party is not automatically entitled to more money. But the court would look at various things. There may be a stronger claim for sharing in post-separation income if the post-separation income, increase in income, is directly related to what happens during the marriage. If the receiving party, their sacrifice during the marriage directly led to that post-separation increase in income, then the receiving party would be entitled to an increase in spousal support. And so the receiving party must demonstrate a contribution, and it can be a direct or indirect contribution. And so the analysis should therefore consider the length of the relationship, because naturally the longer the relationship, the greater the extent of the receiving party's contributions and sacrifice, both during the relationship and even after separation. And so, if one party wants to prove to the court that they're entitled to that, to the benefit of that post-separation increase, they should provide evidence of their contributions during the relationship that supported the pair's financial progression post-separation. And so, by and large, the longer the marriage is, a longer traditional marriage with children will justify a substantial sharing of post-separation income increase. And so the length of the marriage is important, because if, as opposed to a 5-year marriage, a 14-year-old marriage where the spouse has been contributing significantly in terms of childcare, cleaning, and other household chores, and the court may determine that that person is entitled to spousal support, which is based on the income increase of the other party after separation. So what this case does is that it clarifies entitlement and post-separation income sharing. It reinforces that the appeal court often defers to the lower court in support cases. In other words, the appeal court will not easily upturn a finding of a lower court. And quite importantly, spousal support guidelines are flexible. I mentioned earlier there's a divorce mate calculation. That does not mean that courts will abide by those calculations. They do that for child support. But in terms of spousal support, the guidelines are flexible and they're not formulas, especially in high income cases. And the basic thing that the court abides by is fairness and the equitable sharing of resources. That is the guiding principle for the courts. Okay, and so we can move on now to the child support case. And that case is John versus Laing. And that is a 2025 case that was decided in the Ontario Court of Justice. And by way of background, this case involved unmarried parties who had one child together. The father was a former Paralympic athlete and he received sports grants, Canada sports grants. The mother, primary caregiver, the child always lived with her. Now, there are other issues in the relationship, such as, for instance, the father was charged with assaulting the mother. He was placed on a peace bond. And the litigation started in 2024. Initially, the mom did not ask for child support, but she later amended her pleadings and asked for child support. And one of the main issues here was that the father failed to disclose his income, and his pleadings were initially struck out. And so the issues before the court were that of retroactive child support, imputation of income, and how should the court treat the non-taxable Sports Canada grant, whether the court should treat it as income or not. And so let's talk about retroactive child support. The court discussed the fact that retroactive child support is a debt. So by default, there's no reason why it should not be awarded unless there are strong reasons not to do so. It's a debt. The court also mentioned that there should be effective notice. For instance, if child support should have been payable since 2010, and a party brings an action in 2026, then there might be some unfairness attached to that. The court looks at when was notice given, when did the issue of support, when was it broached with the other party? And the court requires, the court looked at the fact that there should be some amount of formal notice in the form of written communication or filing of court material. And taking all of that into consideration, on the basis of fairness, the court usually caps retroactivity at 3 years before formal notice. So if, for instance, if you file court proceedings in March 2026, and you're seeking not only ongoing support, but also seeking retroactive support, the court goes back 3 years. The court will go back to 2023 and look and calculate retroactive support from 2023. And this is done on the basis of fairness. It probably will not be fair to the other party for the court to go back 10 years or 8 years. So it's usually capped at about 3 years. However, the court may depart from that 3 year on the basis of delay, on the basis of a party's conduct, and on the basis of hardship by the support payer. So in this particular case, the court found that there was effective notice. Notice was given on November 30th, 2018. And then there was formal notice when the case was filed in 2024. But because the case was filed in 2024, the court capped retroactivity to April 2021 using that 3 years. And so the court orders support from May 1st, 2021. And so on the basis of retroactivity, that is how the court looks at it. And the court also dealt with the issue of imputation of income. In terms of the imputation of income, the court looked at a legal test that we will discuss later, but the court also looked at the issue as whether, in support cases, lots of people claim unemployment for various reasons, or they're underemployed. Sometimes it's deliberate so that they can avoid paying support. The court looks at that to find out whether it's intentional. Is underemployment justified also by education, the child, or the health needs? And then in terms of imputation, the court will determine what income should be imputed. Should income be imputed at minimum wage, or should income be imputed at a higher range given the party's qualifications and their experience? But in this case, the father provided no evidence of injury, job search, or income. So in terms of imputation of income, who has to prove that income should be imputed? The onus is on the party who's seeking to impute an income to the other party to establish that the other party is intentionally unemployed or underemployed. And so the party claiming support must prove that, either that person deliberately left their job, they're claiming to be ill and they're not really ill. The receiving party, the party who wants to receive the support, they have to prove that income should be imputed. And they must establish an evidentiary basis upon which the court can make this finding. And the court inferred also that the failure of the payer to properly disclose their income or to disclose whatever was required would reduce the obligation of the recipient to provide an evidentiary basis to impute income. In other words, if the person receiving the support or who should receive support cannot adequately establish evidence to have income imputed, the court will look at the fact that the payer has not made disclosure and will make a finding that is negative against the payer. The other thing that the court found was that receiving social assistance is not enough proof of one's inability to work for support purposes. And so what factors will the court consider in imputing an income? The court must have regard to the payer's capacity to earn an income in light of such factors as employment, history, age, education, skills, health, available employment opportunities, and the standard of living enjoyed during the parties' relationship. The court looks at the amount of income the party could earn if they worked to capacity. For instance, you're claiming an imputation of income to a party who has not disclosed his income or currently does not work. But that party has never earned $60,000 per year. The most that party has ever earned might have been a minimum wage. In that case, based on the history, the employment history of that party, the court is likely to impute only minimum wage to that party. On the other hand, if a party is qualified, let's say that party is a doctor, an accountant, and has worked in that capacity previously, but is currently underemployed, the court is likely to impute a higher income, perhaps the income that a doctor should earn, or perhaps the income that an accountant should earn, and the court will impute that income to that party. So the court is guided by employment history, skills, and education. It's not always simply an imputation of minimum wage. In many cases, the court simply imputes a minimum wage, but that's based on the party's employment history. Now, lots of payers claim to be ill. Some payers suddenly become ill as soon as a support order is about to be made. But the court will require that payer to prove any medical excuse for being underemployed. And a simple letter from a doctor that has 2 or 3 lines would not be enough. The court will require detailed medical opinion, which will satisfy the court that they're unable to work. And that medical opinion should contain things like prognosis, what is the likelihood that the party will work in the future, things that state, for instance, that the payer cannot work in this capacity, but perhaps they can work in another capacity. So it has to be quite detailed. Quite often I see a letter from a doctor that has 2 or 3 lines saying this person cannot work because of stress or mental health issues. That is not convincing for the court. It must be a detailed medical opinion because, interestingly, courts are used to seeing letters from doctors of persons not being able to work. That, I'm sure judges see that every single day because lots of people are trying to avoid their responsibility and not to pay child support. So it's quite common for persons to turn up with a letter from a doctor that has 3 or 4 lines. So the courts will require something more detailed and something more convincing in order to impute an income or in order to determine that a particular party is unable to earn an income to pay child support. So in that case, we dealt with imputation of income and retroactive child support. And in both cases, a great amount of proof is required. Courts are very serious when it comes to paying child support. And so there should be strong evidence to support either party. So let's talk now about parental alienation. And that case is a C.C versus CHC. Many cases don't name, they just use abbreviations for security purposes. And so in this case, the background in this case is that the parties were married in 2004 and they separated in 2021. They have two children, ages 17 and 14. The parties continued cohabitation after separation for a while, but it was a high conflict relationship, and the father left with the children in August 2022. And subsequently, the children refused to have contact with the mother. And this is common in family law where children lose contact with a particular parent, and that gives rise to the issue of parental alienation. And the opposite to that will be parental estrangement. So the issue that the court had to determine was whether the children's refusal to see the mother was an issue of parental alienation or realistic estrangement or both. And then, of course, in this case, the court would have had to decide what steps to take. So what behaviors did the parents exhibit in this case? The mother was very rigid. She engaged in one-way communication. She shamed the children. She recorded them surreptitiously, and she admitted this. And so she demonstrated some behaviors that were not acceptable. The father was not exempt from bad behavior. He denigrated the mother. He involved the children in financial disputes. He ignored court orders, and he failed to support a mother-child relationship. And, these are the behaviors that led to the estrangement or the alienation between the mother and the children. And so in this case, the court found that this was a mixed case of both alienation and estrangement. But however, the alienation was the dominant factor, meaning that it wasn't simply a fact of the mother being estranged from the children. This was a deliberate act on the part of the father who was trying to alienate the children from the mother. There were evidence of both, but alienation itself outweighed the estrangement. The court also found that the children's rejection of the mother was not fully justified by the mother's conduct. And so that had a large part to play in that. However, the court had to consider the remedies, and the court also took into account the ages of the children. And so what were the options that the court had in this case? Either do nothing and leave the child with the alienating parent. This is not very favorable because courts try to encourage children to have a relationship with both parents. The legislation talks about the maximum contact principle, whereby it's more beneficial for children to have contact with both parents as much as possible. It's for their benefit. And so the court considered doing nothing, but determined that this would simply be rewarding the father's harmful conduct. And so the other option would be to change the parenting arrangement and place the child with the rejected parent. Now, the issue with this it might be effective, but it would be highly intrusive and risky, especially given the ages of the children. When children get to a certain age, it's very dangerous to force them onto one parent that they do not want to spend that much time with. Another option would be reunification therapy, meaning that the children will maintain residence with the favorite parent, but they will be undergoing therapy, and this should help them in rebuilding their relationship with their mom, but it has to be supported by behaviors that on the part of the father and the mother to encourage that relationship. So therapy in itself will not work if the alienation alienating behaviors continue. And the other option would be a transitional placement with a neutral third party, plus therapy, which will aim to reintegrate the child with the rejected parent. But it's important to know there's no guaranteed remedy, and the response must be tailored to the child's age. So, what is done with a 17-year-old is different from what will be done with a 10-year-old. So in this case, the final orders and the key takeaways that we have is that the child should resume contact with the mother. And the court says child here because the older child was 17 and basically that child could decide where they wanted to go. So this was focused mainly on the younger child. So the child will resume contact with the mother. There'll be mandatory counseling and a review hearing will be held in 5 months. The court did not support changing the parenting arrangement due to logistics and stability of the child. And so the key takeaway here is that alienation and estrangement often coexist, and the courts can find alienation without expert evidence. Just give leading evidence, oral evidence, or written evidence alone can lead the court to determine that. Late intervention limits effectiveness. And this is important because there's something called a status quo, which becomes established the longer that the child does not see one parent, then the status quo becomes established in favor of the other parent. And so waiting for a significant length of time before action is taken will limit the effectiveness of whatever is done to repair the alienation. And so timely resolution is critical in high conflict parenting cases. And let's look at the final case. And this case deals with whether a child can choose its own parenting schedule. And this is an Alberta case decided in 2025. Quite interesting. The background is that the child was 12 and a half years old. There's an existing parenting schedule, but the child requested a break from the father's parenting time late in 2024. And based on that, both the mother and the child sought a suspension of the parenting time. The father agreed to pause parenting time, but his proposal was that the child should decide weekly. And that is what the court had an issue with. So what are the key legal questions and principles arising in this case? Should a child decide on a week-to-week basis whether parenting time should occur pending trial or even at all? And the key principles are that the children's wishes are relevant, but they are not determinative. The court will take into account what the children want, but will not necessarily base its decision on that. The court considers the emotional burden of decision-making, and the court does not give a veto power or discretion to children. And so this was a case that involved a material change, whether there was a material change that would allow for the parenting time to be altered. And the court considered that the child's consistent refusal to see their father amounted to a material change. And so the court found that there was a material change without deciding who was to be blamed for that. But what are the key takeaways in this case? In this case, the court suspended parenting time pending trial. However, the court rejected the idea that the child should decide on a weekly basis whether or not that child wanted to see the parent. The court would not want to put that burden on the child. So the court decided that the child does not have to see the father, but more importantly, they did not need to be the ones deciding whether or not to do so. The court did not allow the child to have that burden of making that decision every week. And so again, the court said that the child's views matter, but so does their emotional safety. And the courts must listen to what the child says, but they also should not shift the burden of decision-making onto a child simply because the child is capable of expressing a view. And so there's a difference between giving a child a voice and giving them a choice or a veto. So that is the main takeaway from allowing a child, a 12-and-a-half-year-old child, to decide. Basically, the courts don't want to put that burden on children. When a child is about 16 or 17 years old, then courts allow them to decide where they want to go. But at 12-and-a-half years old, children don't get to decide that they want to go this week or they don't want to go the following week. They either go or they don't go, but they don't decide when to go because they should not be burdened with that decision. And that brings us to the end of the cases that we have discussed in this webinar. There are lots of other family law cases that were determined in 2025 and in other years that are quite important. And so now I'm going to mention a few family law resources that can be very helpful. And some of those are, we have the Legal Aid Ontario, their website is mentioned there on the slide. Their telephone number is also there. There's the Ontario Women's Justice Network. There's the Family Law Education for Women, FLU. There's the FODF. There's the Family Court Support Workers, that's another resource. And then we have the Mandatory Information Program, which that's a support to people who are already part of the court process. There's a Family Law Information Center. There's a Step to Justice. And there's the Family Responsibility Office, which deals with support issues and other issues affecting families. There's support resources for families that are affected by violence and abuse. There's the Ontario Coalition of Rape Crisis Centers. There's a network of sexual assault, domestic violence treatment centers. There's the Victim Services Directory. And there's some other contacts mentioned at legal clinics. The Barbara Scheifer Legal Clinic, the Luke's Place, they offer support, domestic violence on the legal aid. And so there are lots of supports for families that are mentioned. And I trust that you will take advantage of those resources in the event that it becomes necessary to do so. And this brings to an end my presentation. And I thank you very much for listening.
Thank you so much, Valerie. Thank you so much for that very informative presentation. Together, these 5 cases that you spoke about illustrate how family law courts continue to refine the law on separation agreements, spousal support, parental alienation, child support, and parenting arrangements. Thank you, everyone. And thank you so much again, Valerie, for joining us. Bye.
You're welcome. Yeah.